a couple of different points to actually take into play. And before I go into this point and go into the explanation, you are very, very free. Put up as many questions as you like. With Julie last night, there was so many questions, but what we've actually maintained is we're going to couple all of the unanswered questions, as the screen in front of me is flowing of questions, that we'll actually bring them all together, address them all, and then release them to anybody, along with hopefully the CPD as well. So do ask questions, put them through as pragmatic, technical, whatever it is, okay? I'm very, very happy to engage. So the first question really is force majeure, you know, and we'll deal specifically with the JCT. I think that's where most people will be, has been residing in and around. And is a force majeure event actually occurred? Has it actually arisen because of coronavirus? And I think the first starting point is, what is the force majeure in any event? It's not actually an English law concept, it's actually a civil law concept, primarily from France. So it's not going to be implied. So the first starting point is, does your contract actually set out what a force majeure is? And if it doesn't actually expressly set out force majeure as a point of express terminology, it won't be implied into a contract. So if it doesn't expressly provide, there's no implied position to actually suggest that it will be. The real point about it is, though, that when we get something like the JCT, what we're actually suggesting is a force majeure. People generally would suggest it like the acts of God, like, you know, it covers a wide range of events, either listed or unlisted, and the express terminology of contracts becomes incredibly important. But essentially, it's something that would give rise to to excused performance under a contract, releasing, basically, because of a certain event happening. Foreseeability becomes really, really, really important on this point as well, and the time of contracts. So we'll move into specific elements of what JCT actually provides for, but inherently, if we have a listed or unlisted elements, JCT does not, unusually, it mentions force majeure, but it doesn't actually provide a definition. It's not the capital letters, it's not defined terms that one would expect, and it certainly doesn't set out all of those different points. So if anybody was quite foreseeable in terms of what their contract should contain, and they might have been considering at that time to actually create a defined term, and thereafter, when creating the defined term, what are those listed items? So that becomes incredibly important, because if something is excluded from those listed items, then the question then arises. So in terms of, say, the JCT, if it's not defined or it's not, then, and we don't have terribly much case law in relation to what a force majeure. But the thing about it is, if we were going to now consider as a pandemic, well, WHO has suggested, of course, it is a pandemic, but by its nature, is it foreseeable? Is it any of those points? The very fact that it was actually born from interaction between, obviously, a crossover virus into humans, etc., then one has to consider, like, you know, how that actually transpires and what that then relates to. The fact that, you know, globalization in terms of this was evidently in China just prior to Christmas, is this now a point that with globalization should have been considered throughout, whatever, like, and those points? And I think as well that when you suggest back to MERS or SARS as being examples back in 2002, certainly the foreseeability element could be related back to that. But these are elements that would have to be tested, and, you know, there's no suggestion to say that as disputes occur, and no doubt they will, upon this point. But we then move into, if it's not a force majeure, if it doesn't set out expressly what it is, do we then go to another element in contract law, which would be term frustration? Is the contract frustrated? And incidentally, it's not frustration should not be seen, it's a term here, it's not the fact that parties have become frustrated. So there's certain elements. So if I go back to Taylor versus Cadwell, or if I go back to certain case laws that actually set out the doctrines in relation to frustration, frustration occurs and it does release the parties from further performance, but on certain accounts. So therefore the subject matter might be destroyed, or a certain law might be brought in which would make the performance of the contract illegal. There are certain events that would happen in that case. In this instance, it's really important to think of frustration that the contract is no longer going to be performed. The subject matter is destroyed. So if I was to give an example, I think it was King George. He was in a procession at one point, and there was tickets sold to see the procession. He became ill beforehand, didn't attend, and therefore was the subject matter of the buying of those tickets to see the procession. The whole purpose had been destroyed. They clearly weren't turning up just to view an empty road. So the subject matter had been an issue there. We're not particularly thinking along those lines, because if we think about this is a considerable disruption, but we're now looking at the point to say, has the performance of any of the contracts we're all entered into, have we actually been a point, are they destroyed? And they might be impeded, there might be delays, there might be all of those different points, but the question then will be, can they be capable of performance? So if the parties, we all get back into the general run of things, will it be now the case to say, well, they have been heavily disrupted, there certainly will be cost and time elements towards that, but does that actually suggest, and does that give the indication that the contracts can't be performed? It's very difficult actually to say the contracts can't be performed at that point. So I'm going to turn to one of the first questions, which is on my project, the definition of force majeure was amended to include pandemic, and therefore under the JCT standard 2016 contract, they appear to be entitled at time, but not loss and expense. Is this correct? Okay, so moving in, I think this leads in quite nicely actually when we talk about JCT. So if we look at what the redress, if you're actually in a position where the express terminology and you can capture and bite into a force majeure. So let's take, for example, the argument surrounding whether or not it's a force majeure event that's been done away with, it's been established that it is. Let's take that example. Then what's the consequences of that? So if we take an unamended standard form of JCT, what we actually find is under, say, SBC clause 2.21.1, we were actually looking at that. It's a relevant event. And it actually sets out that force majeure is a relevant event. So ordinarily, if that's going to delay the date of completion, ordinarily you would actually step out to say that a notice would be provided under general rules of contract as a relevant event, what that would be, setting out what the relevant event is. So clearly it's a force majeure. When you became aware or ought to become aware, the material circumstances, and of course what the cause of delay is. Okay, so you would follow then the notification of that, and that would actually be the relevant event. But in turn then, conversely, the next question then becomes to say, well, if we were actually looking at, say, money element of it, so if we go to section 4, if we go into the relevant matter, we'll actually subsequently see that there's no provision there for force majeure. So the indication, of course, therefore is that if it is established, and if it is established that force majeure is this event that has occurred, ordinarily under the standard unamended terms of JCT, for example, you will actually face the point that it would be an extension of time, but parties would bear their own costs. That's certainly under those points. And therefore, it's extremely important then that we actually now fall back into the contract provisions if we get to that point. And I think that the next instance that becomes really critically important then is that we start looking towards the particulars of the contract. We start looking at what is the drafting points, if there's a position of deferment of possession, is there a suspension for a period of time? The default, by the way, being 2 months if it's not stated otherwise. And what effect that does have, because we're now moving into a position where we're now engaging on Section 8. And Section 8 is clearly in around the termination routes. So if the default lasts for, if we have established those points, if we have established that we're now engaging on Section 8, 8.11, we're now looking to say if the period of suspension is over the default point in time, we're now talking about the two parties that may actually disengage and release each other essentially from further performance. So we have different stages of how this actually affects the current contracts. And the point I'm trying to make on this is pretty clear that even most parties in the last week or so have been really engaging on the term force majeure. But that's not the only aspect of contracts that can be mobilized. So for an example, the government would have been very, very careful, and anybody listening to how they've carefully worded the instructions, directions in relation to work. We know everything that's going on at the moment with sites. Some sites are open, some sites are not. There's been so many questions relating around health and safety. There's been so many times running around, like, the social distancing on the sites themselves or close proximity working. But inherently, we're now looking towards how does it actually affect the general operation. When the governments actually don't provide a legislative direction, if you like, or if it's not underpinned by a statutory power, if it did, what you would find then is you would actually find another route. You would find actually throughout the relevant event and the relevant matter through any statutory positions, and that would lead into an instruction. But there's also different elements that one might take as well, but I think that's the primary thing, and I don't think that has been engaged yet. They appear to be more advisory at this stage than certainly having the full force of what the government actually provided for. So I certainly think that that's one of the positions that has certainly become very, very evident. But in terms of, say, where we actually stand and how it actually provides, when we actually think to the stage of how different interactions, so the most common points that are coming forward is the interactions between employers, contractors, subcontractors, and how the performance of any of those contracts are now entering into these areas. The most common point that's been put forward to us is that if there's a shortage of labor, do we have these sort of clauses that are sort of strike, lockout, any of those points? And they don't seem to be mobilized either. And do remember what I said beforehand, this is not a particular area that there's quite a lot of case law, especially in terms of construction contracts, about the force majeure or any of those points. So now what we have to do is we have to go back to actually what the contracts provide for and what the express terminology. One of the key real points that's really been repeated again and again is that we have a lot of clients who are going into contract now. They're fully in the negotiation point of view. Clearly, they're concerned about what will happen, how that arises. So deferment is becoming a question. But also now, one must expect that if you're now going into contract, and remember I mentioned the word foreseeability earlier on, that becomes incredibly pointed now, because if you enter into contract now and you don't, like, it's clearly foreseeable that this is an issue. It's clearly foreseeable that there could be an effect on the contract. So therefore, this is anybody entering into contract or certainly looking towards that now, this is an incredibly important time. It must be mentioned, expressly drafted, and we spent some time in doing those and refining the wording and refining what the events or what the monetary terms are. But this has caused a huge amount of confusion, in terms of how parties are to work, what the common duties are as well. So if a site goes into lockdown, what is the nature then? Whose responsibility is that? So therefore, I return back to the different clauses that we would have. We would have clause 2.1, for example, and ultimately the clause stands that the contractor is to carry out the works in accordance and within by the completion date. And the reason why that's particularly important is because the control of the site then becomes naturally very eminent, because we're now talking about insurances. So the detailing point that if a contractor is now going to close a site, if they are going to secure a site, we're now thinking of occupier's liability. We're thinking about the elements of insurance. We're thinking about making the work safe. We're thinking about ensuring that any temporary works, any structures that have been put forward are in that particular point. The duty, of course, then when we consider insurance, and insurance is our contracts, is how we notify those providers as well of the certain effects that is occurring, what the state of play is. And these all then become the point, because what we're actually seeing as well in a number is this cat and mouse game, this chess game going on between different parties at this moment in time, whereby, who stands first. And I've certainly come across instances where there's nominated subcontractors. If they have not performed, and therefore, is that an intervening valve? Is that a prevention from allowing other subcontractors to continue? And they will all transcend back into the natural rules. Okay, so the contract provides for those. We're talking about a disruption point. We're talking about a risk element. Critically, if it's not caught, if the force majeure or any of these elements do not, or the express wording do not cater for these, then we're now looking into a point of view where the risk of time and money then becomes pretty much important. And there is a real considerable point here that the contractor has to face to look at these and see exactly where that stands. The elements of, say, that completion dates, project delivery, the contractor also faces a real prospect that if they are going to attempt to continue the works, any elements of losses or any elements of disruption that they face, the question then arises, you have a duty to mitigate. So therefore, by mitigation, have you taken those steps in the first case? But the key one of the main instances as well, that because there is that ambiguity sitting around, I do believe that this is the time to actually sit and come to the table. And certainly between employers and contractors. If we take the one route, we can easily think to ourselves, well, let's go to the courts, let them decide, was this a force majeure, and let somebody else, even better, let somebody else go to the courts, and we can then rely upon those events then afterwards. But we're now entering into a period of time that this is an environment that was heavily stressed. There was already a rise in a lot of instances of insolvencies of contractors, subcontractors, of the supply chain in any events. It was heavily stressed to that point. We had just come back from Brexit, a number of months ago. Everything was about draft Brexit clauses. How do we actually come around to those points? It nearly seems that much more palatable to a lot of people to be discussing Brexit than what we're currently discussing now. But in those real terms, that what we can foresee is that the cash flow issues that will surround the heavy leverage nature of the industry in those instances become really, really difficult in times to come. And we do foresee that there will be cash flow issues of how those points come through, facility agreements, all of those elements. The nature about if the step down through contracts, have the terms being provided and actually been given force to all of the other ones afterwards. So I think that is the one major item. I don't think that this is an immediate, it certainly is an immediate issue, but to tackle the problem correctly requires that foreseeability, that if we take the time, that we don't understand how long this will presently last for, of course we don't. It's very much a moving target at this stage. But realistically, the idea to understand when or what or how does this look for? Is this now the opportunity for employers and contractors to actually start making some agreements for a certain stage, even qualified if not, in terms of how this is to be dealt with? Is it do we adopt the provisions of what an unamended JCT form would suggest? In other words, you know, time, but parties bear their own costs, or what does that agreement look like? But this is certainly one of the points that really could be foreseeable for any disputes in the future, especially when we face into an uncertain economic nature. Talking to a lot of clients that up until last week, they have a full order book, but the question now underlying them is to say, will that look like that in a month's time? And how will that affect and how will that change? So I think that's one of the main points. I think there is certainly a lot of scope. We've certainly been involved in a lot of negotiation between parties as well to try and make sure to circumvent. It's certainly something that everybody's in with at the moment, and there does seem to be that wanting for collaboration. But again, it really comes back down to the terms of the contracts to step through. Do consider, not only is it a force majeure or a frustration event, do consider, are there other triggering points? Does it in any event actually trigger something else, perhaps another right or another remedy under the contract as well? And ultimately, it's very, very much for discussion points on that. Okay, thanks very much. Okay, I really appreciate it. And I'll let Julie take it from here. Thank you.
Sorry, I had myself on mute there for the general good of the population. I've got another question here, Henry. Managing development control requirements. Patrick wants to know about those.
Development control requirements in terms of development control requirements of the actual issues that we face now at the moment.
Patrick, do you want to clarify that slightly? You've just put, Patrick's actually
just
typed
one,
in managing.
Sorry, just one line, yeah. Okay.
Yeah, managing, yeah, JCT contract provisions.
Yeah, taking into account that clearly if they've actually been developed now at this stage, okay, so if the contract is operational, it'll be very much, yeah, okay, yeah, thanks Patrick. Okay, now we're getting, yeah, keep going there actually, because now it's getting pretty clear and getting to where you are now. So in terms of, say, the main question about this is, okay, it's a management development control requirements. It's a failure to deliver services. So again, this is a point in tow. So one particular question that came out yesterday evening is the processes, and I think what Patrick is actually talking about here is the process of the contract itself. Okay, so if there's a failure to deliver the service, and if there's not an excusable reason for that, in other words, in terms of saying it is a breach. So if you don't fulfill the obligations, remember any time that any lectures or any seminars I've ever provided for was always very much to say that the common intention of time of parties, that they actually, they are very much in terms of what was the common intention. They will measure it again by that. So any failure to deliver the services as specified under a contract inherently is a breach, and it's capable of redress, whatever that redress may be, loss and expense, liquidated damages. So certainly that will be, it will follow. We do return back to the natural rules under that. The point is about, is there an excusable reason for that? And I had a question from a contract administrator yesterday evening, which related to a very pragmatic point actually, which was essentially that they couldn't get to site to actually value the works. So, and it's a pragmatic issue. So did that absolve or did that hinder how they would have to perform? And the clear answer to that was, well, nothing changes from the point of view of payment notices or pay less notices. Whatever your basic calculation and the amount that you tend to pay, as to how you value it, does that look like an agreement between the parties until that, because all interim payments under JCT is a non-account payment of the final account. And certainly, clearly, the obligations still persist. So there is no amendment to the Construction Act. There is no amendment to the Health and Safety at Work Act 1974. They're all still enforced. They're all to be maintained, and they all still have those thresholds. So in answer, it's really that if you fail to deliver, that point is that it is still a breach, the clear question becomes about, is there an excusable position on that that actually allows for redress? So again, we're back to the time and the money element for redress. Okay.
Okay, there was the another question there from earlier from Colin. Could this trigger an X2 changes to the law event?
Sorry, Julie, I didn't catch that.
Sorry, could this trigger, i.e. could coronavirus trigger an X2 event, i.e. changes to the law?
Yeah, the changes to the law in that point of view, okay, so if we were to look back, and I know exactly why that question's been asked, okay, because we're now going into sort of regulatory, okay, you can see the 2020 regulations in terms of coronavirus, okay, so we're now seeing a lot of enactments coming through. The specific details of how they actually trigger, how they affect the contract becomes incredibly important. What I can say is that if you go into a point where, I think I mentioned before with frustration, that if there is a change to a law that would make something, if you like, illegal, for example, of course, absolutely, but we're not talking about to that extent, I don't think. It's whether or not that there's certain provisions that's enacted, a change to the law would actually then provide difference. That is actually covered, and of course we're talking about NEC there, okay, so now we're talking about a compensation event and what to trigger in with that. Naturally, it become true, you would follow through with your early warnings, you'd follow through within the compensation event of notifying it within the certain timelines and the redress, but you've also got statutory instruments. So the key thing about it is what does the actual change in law actually seek to do? What's the purpose? So I'm going back to the likes of Pepper and Hart here, like, you know, really going back into constitutional points, but it's very much like, you know, what is the purposive approach, or, you know, the literal. So if a trigger is in, and if it actually comes towards that, now if it's a provision for payments or making sure that the supplementary payments to employers, it's simply not going to trigger any of the points. But if the law in terms of the operation of the contract, that would become a statutory point of that, but it would be very much the linking towards that, because essentially as well, we then have to take back to, even if we do get across all of these lines, even if we do, we still have to prove our claim. So even if you did buy in that there was a change in the law, even if you do buy in that there's a force majeure, even if you do buy in that there was a relevant event, and if you have made provisions for express agreements, we still have the natural point of causation. We still have all remoteness losses. The burden of proof remains the same. So if you did start arguing a force majeure and you won on that liability point, quantum element is like the burden of proof still remains the same. Like, know that you have to prove the loss directly causal, on a causation issue against those losses. And to a point as well, like, know that now we talk about causation, this is the time that records become incredibly important. Who is located where, what is actually occurring, what losses, how do we measure loss? And like, we're really into these nice arguments about terms of saying the likes of suggesting what the records actually contain. So consider this as like one of those very difficult type of disruption claims. It's much easier to know and see if you immediately just stop. But if parties are continuing through and we have all of these aspects of supply chains being affected, subcontractors, just general people getting to places of work, records become incredibly important. Anybody who's ever heard me speaking about delay analysis or window analysis, if you have that type of sophistication, there's absolutely nothing wrong to actually now start talking about suggesting, say, you know, a window analysis, like create its own delay event for these sets of period of time, the resources, what losses have been occurred. Because no matter what, even if we did prove that it was any of these intervening events, even if we did prove that it was a relevant event, we're still going to have to prove the time element. Even if we are lucky enough, or if there's an express agreement in terms of money, those rules have not changed. I really want to get that message across. So diaries and the contemporaneous evidence is exactly now. There's very little points. And I suppose as a very last point, as a last comment on it is the insurances. We all maintain insurances as a point of view of businesses, so many different coverages. You'll certainly hear Sharp talking very, very shortly, who'll certainly talk about insurance, but this is something to really review and engage with either the broker or the insurer itself. What type of policy, what does it look like, how does it actually persist? The extension of those points of view, if you're talking about PL, car policies, just to ensure that they're all fully operable, especially during times of suspension, hoarding, all of access points, security, everything is there. Okay, thanks very much.
Okay, thanks everybody. CPD certificates will come out to you in due course, and copies of the answers to the questions from tonight's seminars will be put onto the web very shortly. If you've got any other questions, please feel free to email us directly. We'll do our best to answer as many as we can. We've got a full schedule coming out of more online seminars to do with basic core topics as well as COVID specials. And we're also looking to do an Ask the Expert panel at some point, potentially Thursday next week, where we will have our own internal experts from property, construction, insurance, as many of the different contract types as we can get onto one space, and then we'll be able to happy to answer all your questions for you. For those of you that are coming on to part 2 of this conference, it is a separate link. So I'm going to be closing the room down now shortly, and then we'll see you again at 6 o'clock for John Sharp on the insurance angle of COVID. Thanks all for your time. Thank you for turning up. It's much appreciated.